Well, we have two new filings in the Dollarhide deer watching case. So let's have a look at the first one. It's a response in opposition to plaintiff's motion to file first amended complaint by defendants Lyon and Sharp. For their response in opposition to plaintiff's motion to file first amended complaint, defendants Lyon and Sharp state the following. Plaintiff seeks to file a first amended complaint adding his wife Heather Dollarhide and his daughter MCD as additional party plaintiffs. Plaintiff's proposed first amended complaint asserts three theories of recovery under 1983 (1) infringement of plaintiff's First Amendment rights to free speech, 2 unlawful request for identification in violation of the Fourth Amendment, and 3 violation of procedural and substantive due process under the 14th Amendment. The proposed first amended complaint also asserts four theories of recovery under state law, 1 assault and battery, 2 false arrest, 3 false imprisonment, and 4 intentional infliction of emotional distress. In support of his claims, plaintiff references a YouTube video of the incident. The video has been made part of the record. 1. Plaintiff's motion to amend should be denied under the rule of Robbins v. Oklahoma because his proposed first amended complaint fails to allege who did what to whom in a manner sufficient to overcome dismissal. A proposed amendment is futile if the complaint as amended would be subject to dismissal. In 1983 cases such as this, where the defendants include government agencies as well as government actors sued in their individual capacities, failure to make clear who is alleged to have done what to whom will result in dismissal. Plaintiffs must make clear in their complaint exactly who is alleged to have done what to whom so that each individual defendant has fair notice of the claims against him or her as distinguished from collective allegations against the state. Even when a cause of action arises under state law, federal courts apply federal pleading standards to the state law claim. Use of either the collective term defendants or a list of the defendants named individually, but with no distinction as to what acts are attributable to whom, is insufficient to overcome a motion to dismiss. Here, the only references to defendants Lyon or Sharp in plaintiff's proposed amended complaint are in paragraphs 4, 6 and 21. Paragraph 4 merely states that Mike Sharp is a trooper employed by the Oklahoma Department of Public Safety Marine Division. Paragraph 6 merely provides that Sergeant Lyon is a park ranger. Paragraph 21 consists only of the conclusory allegation that all named defendants are responsible for the arrest and detention of Jason without a warrant and without probable cause. The proposed amended complaint does not show what defendants Lyon or Sharp are alleged to have done, whether they were even present during the incident, or what theory of liability plaintiffs are seeking to use to hold them liable. For this reason, any purported claim against defendants Lyon or Sharp must be dismissed under the rule of Robbins v. Oklahoma. 2. The proposed first amended complaint fails to state a claim against defendants Lyon or Sharp for infringement of plaintiff's First Amendment rights. Plaintiff's First Amendment claim is directed only at defendant Dickens. No allegation involving the proposed First Amendment claims have been made against defendants Lyon or Sharp. If plaintiff was attempting to assert a First Amendment claim against defendants Lyon or Sharp, the proposed First Amended complaint is insufficient to do so because it is completely silent on what Lyon or Sharp is alleged to have done that violated the First Amendment. Thus, it fails to state a claim against defendants Lyon or Sharp under the rule of Robbins. 3. The proposed First Amended complaint fails to state a Fourth Amendment claim against the defendants Lyon or Sharp. Plaintiff's Fourth Amended claim is directed only at defendant Dickens. Plaintiff alleges that Dickens had no probable cause to demand Jason Dollarhide or Heather Dollarhide's identification. No allegation involving the proposed Fourth Amendment claims has been made against defendants Lyon or Sharp. If plaintiff was attempting to assert a Fourth Amendment claim against defendants Lyon or Sharp, the proposed First Amended complaint is insufficient to do so because it is completely silent on what defendants Lyon or Sharp are alleged to have done that violated the Fourth Amendment. Thus, it fails to state a claim against defendants Lyon or Sharp under the rule of Robbins. 4. The proposed First Amendment complaint fails to state a due process claim against defendants Lyon or Sharp. Plaintiff's due process claim is not directed at any specific defendant. Plaintiff merely recites an abbreviated version of the elements of substantive and procedural due process claims and then avers that a review of the 32-minute YouTube video is a shock to anyone's conscience. If plaintiff was attempting to assert a due process claim against defendants Lyon or Sharp, the proposed First Amended complaint is insufficient to do so, because it is completely silent on what they are alleged to have done that violated the due process clause. The video is of no assistance because there is no reference to defendants Lyon or Sharp therein, and it is unclear whether anyone depicted in the video is defendant Lyon or defendant Sharp, or if so, what it is that they allegedly did that violated the due process clause. Thus, the proposed First Amendment complaint fails to state a due process claim against defendants Lyon or Sharp under the rule of Robbins. In addition, all of plaintiffs' claims in this case focus on freedom of speech and freedom from detention. These rights are covered the First and Fourth Amendments respectively, not by the 14th. When a Bill of Rights amendment covers the constitutional interest at issue, it is the Bill of Rights that governs the right rather than the more general due process clause. Thus, when a plaintiff seeks to assert a claim based on substantive or procedural due process, the claim is properly dismissed if the constitutional interest at issue is covered by a Bill of Rights provision. Furthermore, where, as here, there is no contention that it was practicable for the state to provide a pre-deprivation hearing, and where state law permits tort claims against the state to redress alleged deprivations, there can be no Section 1993 claim for procedural due process. Oklahoma law provides for tort claims against the state. Thus, plaintiff's procedural due process claim is precluded by Parrott. 5. The proposed First Amended complaint fails to state any state law claim against defendants Lyon or Sharp. Plaintiffs' proposed state law claims for 1. Assault and battery, 2. False arrest, 3. False imprisonment, and 4. Infliction of emotional distress contain no allegations showing what defendants Lyon or Sharp allegedly did to incur liability under state law. The assault and battery claim is directed only at Trooper Dickens. The false imprisonment and infliction of emotional distress claims are devoid of any reference to Lyon or Sharp, and the false arrest claim contains nothing more than the conclusory allegation that all named defendants are responsible for the arrest and detention of Jason without a warrant and without probable cause. The burden rests on the plaintiff to provide fair notice of the grounds for the claims made against each of the defendants. Thus, the proposed state law claims fail for the same reasons plaintiffs' proposed 1983 claims fail. They do not show who is alleged to have done what to whom as required by Robbins. The Robbins pleading standard applies when evaluating state law claims. Conclusion. For the reasons stated above, plaintiff's proposed First Amended complaint fails to state a claim against defendants Lyon or Sharp upon which relief can be granted. For this reason, it would be futile to allow the amendment. Thus, plaintiff's motion for leave of the court to file First Amended complaint should be denied with respect to defendants Lyon and Sharp. Right, and we have another one, which is, this is a response by Dennis Dickens. Response to plaintiff's motion to file First Amended complaint by defendants State of Oklahoma and Dennis Dickens. For their response to plaintiff's motion to file First Amended complaint, defendants Dennis Dickens and State of Oklahoma state the following. Defendants State of Oklahoma and Trooper Dennis Dickens do not object to plaintiff filing his proposed First Amended complaint with respect to the claims against them. Should plaintiff elect to proceed with filing, defendants State of Oklahoma and Dickens reserve their right to seek dismissal under Rule 12b. By not objecting to the filing of the amended complaint at this juncture, neither the State nor Trooper Dickens intends to waive any substantive or procedural defences they may have to plaintiff's claims, including but not limited to sovereign immunity, 11th Amendment immunity, and qualified immunity. and that's been submitted. Thanks for watching.